of governmental functions that remain after legislative and judicial functions are taken away. The Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts or branches of the government have been sufficiently differentiated, and consequently, it can very well be said that our Constitution does not contemplate assumption by one organ or part of the state of functions that essentially belong to another. Now, my Lord, please turn over the page to para 15. If your Lordships kindly look at Placitum B, the second sentence, our Constitution, though federal in its structure, is modelled on the British parliamentary system, where the executive is deemed to have the primary responsibility for the formulation.
Where are you reading?
Well, para 15, second sentence. Our Constitution, though federal in its structure, is modelled on the British parliamentary system, where the executive is deemed to have the primary responsibility for the formulation of governmental policy and its transmission into law, though the condition precedent to the exercise of this responsibility is its retaining the confidence of the legislative branch of the state. Then, my Lord, in para 16, your Lordships may notice the second sentence. Under Article 53(1) of our Constitution, the executive power of the Union is vested in the President. But under Article 75, there is to be a Council of Ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. The President has thus been made a formal or constitutional head of the executive, and real executive powers are vested in the ministers of the Cabinet. The same provisions obtain in regard to the government of states. The governor or the Raj Pramukh, as the case may be, occupies the position of the head of the executive in the state, but it is virtually the Council of Ministers in each state that carries on the executive government. In the Indian Constitution, therefore, we have the same system of parliamentary executive as in England, and the Council of Ministers, consisting as it does of the members of the legislature, is, like the British Cabinet, a hyphen which joins a buckle, which fastens the legislative part of the state to the executive part. The Cabinet, enjoying as it does a majority in the legislature, concentrates in itself the virtual control of both legislative and executive functions. And as the ministers constituting the Cabinet are presumably agreed on fundamentals and act on the principle of collective responsibility, the most important questions of policy are all formulated by them. Well, this is, if I may say so with great respect, relevant because one needs to understand why is the governor and the president endowed with the authority to give assent to legislation. Well, that was something which your Lordships were inquiring of us. The reason is, my Lord, if all executive power is vested in the president and in the governor, there must also be an imprimatur for certification in relation to the bills which are passed by the legislature. My Lord, as rightly pointed out, neither the president nor the governor, even though they are stated to be a part of parliament and the state legislature respectively, ever participate in the affairs of the house. They do not have the right to vote. They do not have the right to participate in its deliberations. The messages which are, my Lord, sent to the house by the president or the governor are messages which are, my Lord, on the aid and advice of the Council of Ministers, including, my Lord, the message of returning a bill or reconsidering the matter by the House. I'll make it good, my Lord, in a little while. So, in other words, my Lord, at all points of time, the president and the governor do not have any kind of discretion for the purpose of dealing with either the executive government or the acts of the legislature. The reason, my Lord, why I'm mentioning this is, it is on account of this interpretation that in Keshavananda Bharati, the majority took the view that if there are implied limitations on the amending power, because the governor and the president are only eo nomine the constitutional heads, and parliamentary democratic form of government is the method we have adopted for the purposes of popular representation. That is how, the theory of implied limitations on amending power was discovered. I'll just place that, my lord, in a moment. My lord, the next judgment I wanted to place for your lordship's consideration is Sanjeevi Naidu. My lord, that your lordships will find is V49, Roman 549. My lord, this judgment is significant because I'll then indicate, my lord, how in fact the law developed at that point of time. My lord, please kindly see at printed page 18954.
Page 18.
Well, does your lordship have the fourth line, a minister, right from the top of that page, 18954?
52.
18954, my lord. I'm taking your lordship straight to the relevant passage. So, my lord, the reason why assent is required, my lord, by the president and the governor is because all executive action, my lord, under Article 77(1) and 166(1) has to be taken in the name of the president and the governor. That is why, my lord, your lordships will now notice a minister can only deal with the business that has been allocated to him.
You are reading paragraph?
My lord, this is para 3,
Fourth line.
the fourth line from the top.
A minister can only.
A minister can only deal with the business that has been allocated to him by the governor under the rules. He is not competent to deal with any other business. Motor Vehicles Act has been allocated to the Home Department. Mr. So-and-so transport minister was not in charge of the Home Department. Therefore, his department could not have dealt with functions arising under the Act. Well, this was the submission. And then your lordships will kindly notice para 8. It was urged on behalf of the appellants that the Parliament has conferred powers under Section 68C of the Act to a designated authority. That power can be exercised only by that authority and by no one else. The authority concerned in the present case is the state government. The government could not have delegated its statutory functions to anyone else. The government means the governor, aided and advised by his ministers. Therefore, the required opinion should have been formed by the minister to whom the business had been allocated by the rules. It was further urged that if the functions of the government can be discharged by anyone else, then the doctrine of ministerial responsibility, which is the very essence of the cabinet form of government, disappears. Such a situation is impermissible under our constitution. We think that the above submissions advanced on behalf of the appellants are without force and are based on a misconception of the principles underlying our constitution. Under our constitution, the governor is essentially a constitutional head. The administration of state is run by the Council of Ministers. But in the very nature of things, it is impossible for the Council of Ministers to deal with each and every matter that comes before the government. In order to obviate that difficulty, the Constitution has authorized the governor under Subarticle 3 of Article 166 to make rules for the more convenient transaction of business of the government of the state and for the allocation amongst its ministers, the business of the government. All matters excepting those in which the governor is required to act in his discretion have to be allocated to one or the other of the ministers on the advice of the chief minister. So, my lord, the rules of business which are framed under Article 77.3 and 166.3 are the rules which establish, my lord, the link between the action in the name of the governor and the manner in which, my lord, the executive will function under those rules. Now, my lord, the next judgment I wanted to place for your lordship's consideration, my lord, there's one more sentence in para 10. The first sentence in para 10. The cabinet is responsible to the legislature for every action taken in any of the ministries. That is the essence of joint responsibility. Your lordships have already noticed, my lord, for the president, there is a provision for impeachment under Article 61. There is no corresponding provision for the governor because he holds, my lord, office at the pleasure of the president. Then please see the next sentence, my lord. That is the essence of joint responsibility. That does not mean that each and every decision must be taken by the cabinet. The political responsibility of the Council of Ministers does not and cannot predicate the personal responsibility of the Council of Ministers to discharge all or any of the governmental functions. Since an individual minister is responsible to the legislature for every action taken or omitted to have been taken in his ministry, this again is a political responsibility and not personal responsibility. So, my lord, there is no concept of subjective responsibility in the Constitution. It is either political responsibility exercised by the executive government through the chief minister and the ministers, and, my lord, servants who are subordinate to them, the civil servants subordinate to them. And that is how, my lord, action is taken in the name of the governor. My lord, in R.C. Cooper versus Union of India, my lord, volume V.34, 5.34, my lord, there is a para which indicates, my lord, that even ordinance making power is on the aid and advice of the Council of Ministers. So, my lord, although it is called legislative power, but in sum and substance, my lord, it partakes of the character of executive power, but it's on aid and advice. If your lordships will kindly see that for a moment, please see R.C. Cooper, only one para, my lord, page 13183, para 18A. Volume V.34, my lord. It starts at 13156, but the relevant para is 13183.
There is a doubt about all this.
No, my lord, there is no. I am only indicating, therefore, my lord, there has been a suggestion in the submissions of the Union of India that the president and the governor exercise discretion. My lord, that is fundamentally flawed. I'm submitting for your lordship's consideration. Once we answer this question correctly, then your lordships would be able to appreciate whether there is any vestige of discretion in the matter of a bill or the assent, which, my lord, I'll just now quickly come to. Now, please see para 18A, page 13183, my lord. (5.34), my lord. Please see in para 18A. Under the Constitution, my lord, this is just at printed page 1383, bottom.
13183.
Under the Constitution, the president, being the constitutional head, normally acts in all matters, including...
So you are reading para?
I'm so sorry. 18 capital A.
Yes, 18 capital.
Under the Constitution, the president, being the constitutional head, normally acts in all matters, including the promulgation of an ordinance on the advice of his Council of Ministers. Your lordship finds that, my lord? Yes. Whether in a given case, the president may decline to be guided by the advice of his Council of Ministers is a matter which need not detain us. The ordinance is promulgated in the name of the president, and in a constitutional sense on his satisfaction, it is in truth promulgated on the advice of the Council of Ministers and on their satisfaction. The president is under the Constitution, not the repository of the legislative power of the Union, but with a view to meet extraordinary situations demanding immediate enactment of laws, provision is made in the Constitution investing the President with power to legislate by promulgating ordinances. Now, my lord, I come to UNR Rao. My lord, that is important. Again, my lord, I'm indicating the importance of the cabinet form of government. And the cabinet form of government is relevant, my lord, to determine the ambit of discretion of the President and the Governor. And therefore, if the principle of collective responsibility is owed by the cabinet to the legislature, my lord, the Governor is outside both these. The Governor is outside a cabinet. The Governor is not collectively, is not in any way responsible, my lord, to the legislature. The Governor is responsible only, my lord, to the Constitution and to the oath of office and to the courts. But, my lord, otherwise, he is not responsible to the legislature in any way. Now, in UNR Rao, my lord, again this question arose, and the court said, our Constitution never contemplated, even for a single moment, that there would be no Council of Ministers. Even after, my lord, the dissolution of Parliament under Article 75, my lord, Chief Justice Sikri read Article 75.1, 75.2 and 75.3, my lord, in harmony to say that there shall always be a Council of Ministers, and that is the mandate of the Constitution. So, my lord, that is the position as far as UNR Rao is concerned. May I request your lordships to just note the relevant paras. I don't need to read them. They are paras 3, 6 and 7 and 9, my lord. And para 9 clearly says...
What is the address?
Oh, my lord, the address is V34, Roman 534. It starts at, my lord, page 13276. The relevant paras are 3, 6, 7 and 9.
Volume? V?
3, 6...
No, volume.
Volume, my lord, V34.
Same volume.
Roman 534, page 13276. The relevant paras are, my lord, 3, 6, 7 and 9. And in 9, my lord, there's a reference to aid and advice of the Council of Ministers.
7, 6.
So, my lord, aid and advice of the Council of Ministers is, my lord, central to our constitutional democratic governance. So, my lord, there are different forms of democracy. You can either choose a presidential form or you can choose a parliamentary form. We have chosen, my lord, a parliamentary form, both in terms of the centre and in terms of the state. And that is why, my lord, the element of aid and advice is so central to the Constitution. So when, my lord, under Article 163(1), that expression in his discretion under provisions by or under the Constitution, there are specific provisions. The reservation, my lord, for the President also takes place only on the aid and advice of the Council of Ministers. So, my lord, a law which needs the assent of the President under Article 31A, 31C, 254(2), 288(2), all of them, my lord, they are reserved by the Governor for the consideration of the President for his assent. It is also only by aid and advice of the Council of Ministers. So, my lord, there is no position in the Constitution where the Governor acts in his own discretion, except, my lord, in two cases. One, when he submits a report to the President under 356, or when he, my lord, takes a position contrary to the position of his cabinet in assenting to a law which detracts from the jurisdiction of the High Court. These are the only two positions, my lord, apart from those special provisions in Article 371A, D, E, F, G, H, I, and, my lord, para 6 schedule, paras 20BB and 20AA.
The paragraph you are relying on in...
Yes, now, my lord, I'm coming to Keshavananda Bharati.
3, 6, 7 and 9.
No, you are not wrong.
Oh, in UNR Rao. I'm sorry, my lord. In UNR Rao, paras 3, 6, 7 and 9.
Yes.
Lord, your lordships may take it. I'm stating the proposition accurately from the judgment. So I'm proceeding to the next one. Well, this is an important judgment because what these submissions of the union seek to do is, my lord, indirectly abrogate, shall we say, the fulcrum of the Constitution, which is the cabinet form of government, and the responsibility to the legislature. My Lord, in Keshwananda Bharati, the judges wanted to consider whether Article 368 had any limitations. My Lord, there were no express limitations, but they wanted to examine whether there are any implied limitations on the amending power. To discern, my Lord, a limitation on the amending power of Parliament, they said, if under our Constitution, the President and the Governor, who seem to enjoy untrammeled discretion if you go by the words of the articles, like on his satisfaction, in his opinion, but in truth and substance, they have very limited power. Because they have very limited power, the court said, we believe that there is something called implied limitations. So even though the express words in relation to the Governor and the President, again, my Lord, to borrow the language of the learned solicitor, indeed suggested some sort of plenitude of powers, but they said no. In substance, the Governor and the President stand on the same footing, and because we see this limitation, therefore, this is a part of the basic structure. What is a part of the basic structure? That is the democratic form of government through a cabinet is a part of the basic structure. And they said no amendment can be passed. Well, I'm the majority opinion, took the position it cannot be passed. Well, the theory of implied limitations was noticed by Chief Justice Sikri, Chief Justices Shelat and Justice Grover, Justice Hegde and Justice A.K. Mukherjee, and my Lord, Justice Jagan Mohan Reddy, who read it slightly differently. Justice Khanna took the view that if you attempt to change the form of government, that's a democratic form of government, then in that case, it is a case of abrogation of the Constitution, which is outside the amending power. My Lord, it's a long judgment. I can give your lordships the relevant paragraphs from your court record. But my Lord, they make instructive reading because the suggestion of the union, one, they say there is a unitary bias in favor of the centre. My Lord, it is true there are additional powers in favor of centre and Parliament, but my Lord, there's nothing called unitary bias. Second, my Lord, there is nothing called discretion. My Lord, a claim has been made that there is discretion both in the President and, my Lord, in the Governor. That is not true, my Lord. I have indicated that prior to the 42nd Amendment in Article 74, my Lord, the provisions of Article 74(1) were identical to Article 163(1), except for the words, my Lord, in his discretion. Otherwise, the words were identical. And in relation to the unamended article, in Shamsher Singh, because of my Lord Sardari Lal's case and Baburao Upadhyay, these two judgments, they came to the conclusion that aid and advice means it is binding. So in S.P. Gupta's case, Justice Bhagwati said that although we had laid down the principle in Shamsher Singh, that has received a constitutional recognition by the insertion of the proviso in 74(1). And 74(1), my Lord, made aid and advice binding on the Council of Ministers. That is noticed, my Lord, in S.P. Gupta's case. Therefore, my Lord, if you want to see anything of discretion, we have to discover it in the Constitution. My Lord, please see, I'll give your lordships, the volume is, there are two volumes, my Lord, V.50 and V.51. Well, I gave the Supreme Court reports. Well, I gave that because the summary, my Lord, is accurate. If at any time your lordships, my Lord, I'm giving the relevant paras for your lordship's kind consideration. My Lord, this is the authorized, at that time, my Lord, we used to treat it as the authorized version.
Well, we could have taken the book.
My Lord, this is V.50. And if your lordships will kindly come to page 19309, your lordships will find Chief Justice Sikri's opinion. 19309, my Lord. And
19309.
309. And may I take your lordship straight away? 19301. My Lord, after citing Ram Jabaya Kapoor in 19309, this conclusion, after my Lord Ram Jabaya Kapoor, Sanjeevi Naidu, please see this conclusion. Your Lordships
Yes.
find that para, my Lord? This conclusion constitutes an implied limitation on the powers of the President and the governors. So, my Lord, if in Keshavananda they read these powers as so limited by its very nature, I submit, my Lord, we cannot now read into these provisions an element of discretion. And, my Lord, 19425, your Lordships will find the opinion of Justice Shellett and Justice Grover.
194.
25. In 19425, my Lord, your Lordships will find in the middle of the second paragraph, it has been implied that the President has been made a formal or a constitutional head of the executive, and the real executive power rests in the Council of Ministers and the Cabinet. Then, my Lord, the articles are recited. Then your Lordships will notice the Minister shall hold office during the pleasure of the President, and the Council of Ministers shall be collectively responsible to the House of the People. Then your Lordships notice this conclusion, which is based on the implications of the cabinet system of government, can be said to constitute an implied limitation on the power of the President and the governors. Well, to the same effect, your Lordships will notice is Hegde and Mukherjee are JJ. Well, Justices Hegde and Mukherjee, which your Lordships will find is at PDF, page 19473, my Lord. The opinion begins. The relevant portion, my Lord, is 19484. 19484. Several of the powers conferred under our Constitution have been held to be... Page 19484. My Lord, this learned judge, Justice Mukherjee, my Lord, he passed away, my Lord, in harness. No, my Lord, this is Arun Mukherjee. This gentleman, my Lord, he would have been the Chief Justice, my Lord, but unfortunately he passed away during the summer recess when he was a vacation judge. Several of the powers conferred under our Constitution have been... Sorry, my Lord, 19484.
Justice Scheller and...
This is, no, my Lord, Hegde Mukherjee.
They reiterated that they did not ask the General Advocate General for State of Maharashtra, who was leading the arguments, to address on this issue in detail. So, because the main issue was with regard to the amending clause of the Constitution.
I quite see that. Now, please see, my Lord, Justices Hegde and Mukherjee. Please see this at just after the quotation in James versus Commonwealth of Australia. Several of the powers conferred under our Constitution. Does your Lordship find that?
Yes.
Several of the powers conferred under our Constitution have been held to be subject to implied limitations, though those powers are expressed in general terms or even in absolute terms. The executive power of the Union is vested in the President, and he is authorized to exercise the same either directly or through officers subordinate to him in accordance with the Constitution. Under Article 75, it is the President who can appoint the Prime Minister, and the officers are to hold office during his pleasure. Despite this conferment of power in general and absolute terms, because of the scheme of the Constitution, its underlying principles and implications arising from the other provisions in this Constitution, this court has held in several cases that the President is a constitutional head and the real executive power rests in the Cabinet. Similarly, though plenary powers of legislation have been conferred on Parliament and the state legislatures in respect of the legislative topics allotted to them, yet this court has opined that by the exercise of that power, neither Parliament nor the state legislatures can delegate to other authorities their essential legislative functions, nor could they invade on the judicial power. These limitations were spelled out from the nature of the power conferred and from the scheme of the Constitution. So, my Lord, I submit with respect, my Lord, Justice Khanna's opinion, my Lord, is at page 19919. My Lord, this is volume V.51. It's the second volume.
19.
19, my Lord, 19919.
19991.
No, my Lord, 19919. Please see, my Lord, the last paragraph. In the last paragraph, my Lord, this brings in the concept of federalism because you have dual governments, one in the center and one in the state. In a federal system, does your Lordship have that passage, my Lord? It's the last paragraph. In a federal system where the spheres of legislative powers are distributed between the central legislature and the state legislatures, there has to be provided a machinery to decide, in case of a dispute, as to whether the law made by the state legislatures encroaches upon the field earmarked for the central legislature, as also a dispute whether a law made by the central legislature deals with a subject which can be exclusively dealt with by the state legislatures. This is true not only of a federal system, but also in a constitutional setup like ours, which the constitution makers, though not strictly adopting the federal system, have imbibed the features of a federal system by distributing and setting apart the spheres of legislation between the central legislature and the state legislatures. The machinery for the resolving of disputes as to whether the central legislature has trespassed upon the legislative field of the state legislatures, or whether the state legislatures have encroached upon the legislative domain of the central legislature, is furnished by the courts, and they are vested with the powers of judicial review to determine the validity of the acts passed by the legislature. The power of judicial review is, however, confined not merely to deciding whether in making the impugned laws of the central or state legislatures have acted within the four corners of the legislative list earmarked for them. The courts also deal with the question as to whether the laws are made in conformity with and not in violation of the other provisions of the Constitution. Our Constitution makers have provided for fundamental rights in Part 3 and made them justiciable. Now, my Lord, before I cite one important passage, my Lord, in Shamsher Singh, there is, my Lord, a debate, a speech in the Constituent Assembly debates of Sir Alladi Krishnaswamy Iyer. There is a reference, my Lord, to the speech in Justice Krishna Iyer's concurring judgment, where, my Lord, the Speaker says that if a president acts in his discretion and does not abide by the aid and advice of the Council of Ministers, he is thwarting the will of Parliament. Well, Lord, that is the principle of aid and advice. That it is by that method you actually secure what is called parliamentary accountability. And, my Lord, this is the basis in Shamsher Singh's case. Why? Because, my Lord, up to this point, there were, my Lord, two judgments which took the view that all these articles gave personal discretion. That is, President had discretion to declare emergency. President had discretion to declare financial emergency. President had discretion to dismiss anybody at pleasure, my lord, under Article 310. When all this was there in Sardari Lal, my lord, they said all these are discretionary provisions. And that, my lord, was actually set right in Shamsher Singh's case. In Shamsher Singh's case, they relied upon two previous judgments, my lord. One of Bijay Lakshmi Cotton Mills, and the second one, my lord, was the Bijay Lakshmi Cotton Mills, and my lord, the judgment in Motiram Dekar. My lord, Motiram Dekar overruled Bapuram Upadhyay. On that basis, my lord, in the judgment in Shamsher Singh, my lord, I'm giving a summary because it's very accurate to see this reasoning. The view expressed by Chief Justice Ray in the majority judgment, my lord, proceeds on the footing executive power is vested only in the president and the governor. And my lord, except for those two provisions and specific provisions, he says they are identically placed and they are bound by aid and advice at all points of time. My lord, that is very significant in this judgment. Now, how is it, my lord, Chief Justice Ray comes to this conclusion is very interesting. He says, under Article 77(3), you make rules of business. Through rules of business, the governor actually acts. Those rules of business are also, my lord, on aid and advice. The rules of business which are framed by the president and the governor are themselves, my lord, products of aid and advice by which, my lord, ministerial allocation of business can be suitably defined. So, my lord, in Shamsher Singh, their lordship said that because of this constitutional scheme of 77 and 166, 77.3, 166.3, 77.1, 166.1, we must necessarily come to the conclusion that it is aid and advice which is binding on the Council of Ministers. In other words, they said, and my lord, the two learned judges have expressed two different expressions. Chief Justice Ray says you cannot have a parallel administration through a governor. My lord, Justice Krishnaiyer and Justice Bhagwati, they said there would be something called a diarchy, which would itself be an anathema to the Constitution. I'll only give the para numbers, my lord, because the judgment has been read over and over. I will only give your lordships the para number, yes, and I'll just make a mention. My lord, please see this is in volume V.7. Shamsher Singh, page 2886. And my lord, paras 17 to 19. 2886, my lord. And in paras 17 to 19, their lordships actually, my lord, notice that the expression in his discretion was consciously deleted. I'm only giving the para numbers, my lord. Para 17 to 19 and para 20. Paragraph 17-19, my lord. Paras 20 and 25. And then, my lord, para 26, which is very important, my lord. They say the president and the governor never exercise this power personally. So even though the words satisfaction, opinion are written in the Constitution, but they never exercise these powers personally. They only exercise it on the aid and advice of the Council of Ministers. And my lord, in paras 27-28, they describe the cabinet system of government and how they are the formal heads of state.
Titular heads.
Yes, that, my lord. This is the position. And, my lord, may I also request your lordships to note para 48, 54 to 56 has already been read, my lord. And Justice Krishnaiyer, my lord, I want to show this important statement of para 109. Sir Alladi Krishnaswamy Iyer's statement at page 2918. My lord, that is an important sentence because that established 2918, my lord. My lord, your lordships will notice
2918 is
para 109, my lord.
109.
109. Please see that, my lord. This is Sir Aladi Krishnaswamy Iyer in the Constituent Assembly. It was provided in the Constitution that the Council of Ministers would be collectively responsible to the House of the People. If a president stood in the way of the Council of Ministers discharging that responsibility, he would be guilty of violation of the Constitution and would even be liable for impeachment. It was therefore merely a euphemistic way of saying that the president had to be guided by the advice of his ministers. The Council of Ministers were collectively responsible to the House of People, answerable to the House in regard to the budget or legislation, and indeed for every matter connected with the administration of the country. Then, my lord, please see, on another occasion he reiterated, the Union Constitution Committee and this assembly have all adopted what we may be called the cabinet system of government. An infant democracy cannot afford under modern conditions to take the risk of perpetual cleavage, feud, or conflict or threatened conflict between the legislature and the executive. So, my lord, this gives your lordships an overview. My lord, my colleague, Mr. Anand Sharma, he is somewhat severely constrained. He is not in a position to appear on the next occasion when your lordships assemble. I thought, my lord, if your lordships do not consider it inappropriate, may I, my lord, pause here and allow him to urge his submissions, my lord. I think out of abundant respect, I do owe this to Mr. Sharma. And I will resume, my lord, and complete my submissions on Tuesday.
How much more time?
My lord, I'm going swiftly, my lord. I'm coming to the next point. There are 2 points, and I won't, my lord, in fact, I will not even take the fully requested time. I would take an hour at the maximum. I just want to place this, my lord, in some context.
He concludes. Can you take over after him today?
So, certainly, my lord. I'm
In any case, you are here only. You are the only person who has been constantly here.
I'm not going to leave.
You are the only person who has been consistently and constantly here.
Obliged to you.
And if you go by Mr. Sibul's advice, Dr. Singhi would not get a chance to address.
I'm an old fossil, my lord. I'm grateful, my lord. May I, my lord, hand over to my learned friend, Mr. Sharma. I'm grateful to your lordships.
My lords, I represent the state of Himachal. I'm deeply obliged the consideration shown, and it's an honor to have an opportunity to make these submissions. At the outset, I would like to express my deepest appreciation and gratitude also to Shri Gopal Subramanya for being gracious in accommodating, as your lordships have been very kind. So, my lords, this presidential reference does seek to reopen many settled issues of law, and at the same time has brought into question and discussion foundational constitutional issues of critical import. This Honorable Court has already addressed, my lords, the question of maintainability, and many learned colleagues have spoken from both the sides. So I feel that to save time, I have very little time, it needs no revisiting as what has been said on this. We have made written submissions and the judgments relied upon that may kindly be taken as read. We have given a short note today which has been circulated, and that is volume 2, Roman 2.7. And along with that, we have attached some very relevant authorities in volume 4.25. I seek to focus, my lords, only on few points. First is federalism, the power, responsibility, and the rights of the Union, and the autonomy of the states. Second, the position, powers, and constitutional role of presidents and governors. Number three, justiciability of decision on bills. Four, the discretionary powers of the president or the governor, separation of power, and the legislature, between the legislature, the judiciary, and the executive. My lords, it's well known that the framers of the Constitution, while grappling in framing the Constitution, it was a historic transition for this country. After centuries of subjugation, for our people to be given a voice, and therefore they were equally conscious that India is a country rich in diversity, multilingual, multi-religious, multi-ethnic, with each region having its own distinct history. I need not dwell more, your lordships are aware. So in their collective wisdom, they decided, and our people decided, those who were well informed of the conditions during the national movement, to make this country a union of states and a parliamentary democracy. The framers of the Constitution, in their collective wisdom, have also put in a place of checks and balances between the executive, the legislature, and the judiciary to perform constitutionally assigned functions which remain distinct yet interlinked. There is no firewalls here. When it comes to the separation of powers, I was thinking this morning, sitting here last few days, returning to the bar after a few years back, I came back after a long gap, that it's so beautiful.
We should have followed Dr. Singhvi, Mr. Sibal.
So I was...
Nobody stopped you from that.
No, my
Mr. Wilson,
situation and circumstances.
Mr. Wilson, Mr. Reddy.
I wish if I had their wisdom and their energy, because I believed in one thing. When I was given responsibilities to focus seriously on lawmaking, to do my work. So, my lord, if I'm allowed indulgence.
You mean to say that they are not serious?
No, I'm not saying, sir. I'm saying, sir, I lack their wisdom and their energy. No, I'm not saying that, please. Well, whatever. What I'm saying, it's a great honor to be back to the profession to which I belong. My late father, who was an illustrious, eminent lawyer, he belonged to this profession, and he never approved of the other passion, what kept me away. So it's a tribute to my father also today. My lords, my lord, the doctrine of separation of powers, as I was mentioning, is not an abstract, but the very foundation of India's constitutional framework. I don't have to repeat how the lawmaking takes place. My very eminent colleagues have referred to that in detail. But it is the legislature which is sovereign, that the parliament or the state legislature, when it comes to lawmaking, when it comes to interpretation, your lordships are the final arbiter. You have to adjudicate what is within the four corners of the Constitution and what is in conflict with that. And that's why India's democracy and the constitutional democracy has sustained itself, whereas many other countries in Asia, Africa, Latin America, which became independent along with us, could not sustain their democracies, could not uphold the citizens' rights. And this is the strength of our republic, my lords. Article 50 of the Constitution has ensured judicial independence. And therefore, that is what matters to the people of this great country, that their rights, as enshrined in the Constitution, are secure, justiciable. They'll get a fair treatment, and their dignity as the citizens of the Republic shall be protected. The President and the Governors, my lords, the issue that has been raised, that whether they have any discretion, the answer is no. Constitution actually does not give any discretion. Even what is mentioned here in few articles, where the bills passed by the Assembly, there is holding of assent by the Governor, and they are referred to the President for consideration. That's also stipulated strictly by the Constitution. There's no discretion or prerogative which was dispensed with in the Constituent Assembly. It was there in the draft that was submitted and discussed, the draft Article 91, but that was done away with, and the amendment to do that, and also to Article 200 to ensure that there was no delays, were moved by none other than Dr. B.R. Ambedkar. We have quoted in our submissions in detail as to how strongly he felt, how strongly his other learned colleagues in the Constituent Assembly felt. The powers, therefore, of the President and the Governors are de jure, not de facto. The executive power is vested entirely in the Cabinet, in the Council of Ministers. The powers to, I'm coming to Article 200, powers to withhold assent, as your lordships know. 2 is conditional. And it's even in the case of recommending bills under Proviso 2 of 200 for the consideration of the President, only a bill, if it becomes a law, so derogates from the powers of the High Court as to endanger the position which that court is by this Constitution designed to fill, or as specifically
Yes.
my lords.
Yes. No.
So I was saying that the proviso is very clear that where the Governor would recommend or send it to the President. In other cases, as specifically stipulated, is Article 31(3), the property acquisition law, which have been discussed and read here, is there in our submissions, Lord. The second proviso of Article 200, which I was referring to, Article 2882, second proviso, the state taxation of interstate river, water, and electricity. Article 304B, any restriction on freedom of trade between states, or 360, a financial emergency. The discretion of the governor does not exist in our constitution. That is the real situation.
That's all. Everybody is on the same page on this side.
Yes, yes. That's why I'm not elaborating further. My lords, the Article 200, as soon as possible, the correct interpretation, ideally, as has been submitted here, means at the earliest. That would be the right way to interpret.
Mr. Sibal has gone forward. He has said forthwith.
Well, my lords, in the draft that was before the Constituent Assembly, as your lordships know, there was a provision, suggestion, or proposal of 6 weeks that was dispensed with and rejected and not accepted.
Not rejected, it was not there in the final draft.
It was not there because it was made clear that there is no room for delay in lawmaking. Going through the debates, it was there in the draft. As I've said, it was discussed also. But finally, that 6 weeks was considered to be a bit longer, not shorter. So when we are talking today, here we are talking of 6 months, 8 months, 1 year. That is where the present discussion is. And that's where your lordships are seized of this reference and the matter. My lords, even in United Kingdom, the sovereign originally had the power to withhold assent. And it's the Supreme Court in the United Kingdom which termed it unconstitutional. Our governors have a role, a constitutional role, so well defined. But if we say that they have the discretion to withhold, or this concept which has been very well explained by many colleagues of the bill falling, which does not exist, which are quite perplexed. Governors, with due respect, I'll submit, are not viceroys or governor generals. They are governors under our constitution, who are bound by the aid and advice of the Council of Ministers. I'm referring to 64 and articles and 173 is in our note that has been given to your lordships. That is from pages 1101 to 1105. I am also bringing to your lordship's attention some very important articles which have so far not been referred to further underscore the submission that legislature is supreme and neither the president nor the governors actually have any role in lawmaking. They are not part of the legislature, though both the president, the parliament starts in the constitution with the president, and the legislature starts with the governor. But even when they come to the parliament to address the joint session or to, in the assembly, the governor, my lords, they don't preside, they don't chair, they only address. And I'm coming to that. And taking it straight to Article 85, the convening of the sessions of the parliament. Listen. Pages 1101 of the volume 2.7 onwards, which deals with the convening, adjournments, prorogation, and the ordinance making. According to Article 85, the President shall from time to time summon each House of Parliament to meet at such time and place as he thinks fit. But 6 months shall not intervene between its last sitting in one session and the date appointed for the first sitting in the next session. And then, Proviso 2, the President may from time to time prorogue the House or either House. In case of legislature, the same apply under a different article, and that in this case is 174. No, 174 is there. Now, the power to summon the Lok Sabha, my lords, is vested in the President. He exercises this power on the recommendation of the President. The proposal to summon the Parliament, and the same would apply, my lords, the summoning of the State Assembly or the legislature, is initiated by the Minister of Parliamentary Affairs and submitted to the Prime Minister. And upon the Prime Minister's approval, the proposal, as finally agreed to by the Prime Minister, is formally submitted to the Speaker, who, upon concurring or agreeing with the proposal, which normally is the practice, because the Prime Minister is the leader of the majority party, which is in government, then the Speaker, through the Secretary General, sends it to the Honorable President to summon the Parliament. Same applies to the state assemblies. And the summons are issued in the name of the President.
Your proposition, what your...
My proposition is, my lords, if I come right up to the Article 86 message. Yes, my lord.
On these articles, what is your proposition?
My proposition is that even to summon the legislature, the President or the Governor have no role. They are bound by the aid and advice
of the
Council of Ministers on their own suo motu. They cannot summon either the Parliament or the legislature. I go a step beyond. Article 86, my lords. The President may address either House of Parliament. This practice evolved of the joint session later under Speaker Mavalankar when a constitutional amendment was necessitated, and it was felt that it should be once annually a joint address. The only departure being when an election to the Lok Sabha is held or a midterm election to the Assembly, then there is a departure. Otherwise, there is one address. Now, that address, which the President has submitted from pages 35 to 38 of my note, but 1105, 06 up to 08. It's important. What I was referring to earlier, and I draw your attention, I submit to Call and Shakhtar, which we have submitted, page 181 of the Practice and Procedure of Parliament, the 6th edition, which makes it absolutely clear. Now comes the issue of the address. That is also approved by the Cabinet, whether in case of Governor or the President. The President or the Governor cannot add, delete even one sentence or one idea They speak on behalf of the Council of Ministers, the Cabinet. The Constitution makes it abundantly clear. It's in the name of my government the address is. And my government will do this, their policies, their priorities. Not I as president, not I as governor. And that
Where,
is the practice, my lords.
where do you get that from? From which articles you get that?
Article 86 is this, and call and Shakhtar, I just, as I mentioned, page here.
So Kaul is here.
No, we have. Paul and Shakhtar. These things is that the president or the governor, that's what they speak, what they say, they address, is on behalf of the government. It's as cleared by the cabinet. If I go further, I had referred in detail about the summoning part. If I may also mention about the prorogation of the House, the termination of a session of the House by an order made by the President under Article 85(2) is called prorogation. And Call and Shakhtar say, page 189, Practice and Procedure of Parliament, they are the acknowledged authorities when it comes to legislature. The termination, volume 4.25, my lords. Prorogation of the House. Termination of a session of the House by an order made by the President under Article 85(2) is called prorogation. The President, in exercising the power to prorogue the House, acts on the advice of the Prime Minister. The Prime Minister may consult the Cabinet before the advice is submitted to the President. Prorogation of the House may take place any time, even while the House is sitting. Usually, however, prorogation follows the adjournment of the sitting of the House sine die. That's on page 189. My lords, we have submitted. And what is the practice after adjournment is very important. Once the President has made the order, it is notified in the Gazette Extraordinary on the same day. But when? When the Minister of Parliamentary Affairs sends a communication to the Speaker, and Speaker concurs, and through the Secretary General.
Remember that the Kaul and Shakhtar may not be relevant for us while we are when we are interpreting the Constitution.
No, in one context.
So we may be guided by the debates in the.
But I am quoting, my lords, the articles of the Constitution.
Mr. Kaul and Shakhtar may be relevant insofar as the procedure in the Parliament is concerned.
But what mentions.
But then that may not guide us when we are interpreting the provisions of the Constitution.
In the Constitution itself, it's abundantly clear. The same thing, what I'm reading from there, that what is the practice? Even on prorogation, also on ordinance, if we look at that, it's crystal clear there is nothing new, which Call and Shakhtar is only referring to and reaffirming that this is how legislature functions when it comes to the summoning, the prorogation, the lawmaking, as well as the power to make ordinance. Now, that is important because when submit Article 123, my lords, power of President to promulgate ordinance, and the similar power in the Constitution also has for the governors. If at any time except when both houses of Parliament are in session, the President is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinance as the circumstances appear. to him to require. Now, here, my lordships, an ordinance promulgated. This is not a legislative power of the president. The same applies to the governor. Under the constitution, it has very short life. It shall have the same effect and force and effect as an act of parliament. But all these ordinances go back to the parliament in the first sitting of the house. And within 6 weeks, if the government of the day does not want to retain the ordinance falls. It has no force of law then. Therefore, a bill is required under the constitution to be brought. The government may bring the bill. The government may not bring the bill. So it was said, if my memory serves me right, which it is good, that it was the learned Solicitor General who referred to the legislative powers. And I was listening very carefully, and my mind raced to what actually that meant, because it does not give any lawmaking powers to the president, to the governor at all. That's why I refer to, there was a reason why specifically my lordship this time to refer to Article 85, 86, 87 and Article 123, which has all been submitted, that right from the summoning to lawmaking, to the enactment of a law, amending the constitution, the president, and in the enactment of laws, the governor, have no role. Yes, assent, which I have mentioned, and it has been submitted repeatedly by learned colleagues. It is very carefully carved out. It is specifically stipulated, does not give any discretion. My lords, I would like to submit that the federal structure, which is part of the basic structure of the Constitution, that is what we have. It has a unitary bias, which is designed to reconcile the autonomy of the states with the autonomy of the states, with the unity of the nation. The very first article starts by declaring us as a union of states. And that is what this reference under Article 143 brings to the fore very sharply. This federal structure of ours is the cornerstone of the Constitution. Both levels of the government, union and states, derive their authority, my lords, from our Constitution and operate within their respective spheres. So the states have their autonomy. That's what the Constitution guarantees. It's not that they become a separate autonomous away from the union, but that has to be borne in mind. And the center-state relationship is marked by a clear demarcation of powers, my lords. Duties and responsibilities are well defined constitutionally. Now, I'll skip some which feel that in our submissions, which are with the lordship, are enough. Our federalism is also India's strength. And many pronouncements of your lordships, which are referred to, have reaffirmed that federalism is part of the basic structure and of the Constitution, which cannot be eroded, diluted, weakened in any manner. Therefore, my lordships, any attempt to redefine or revisit will disturb the equilibrium between the union and the states and has its perils. Reference was made on the day first itself by the learned Attorney General, if I am correct, to the functional disharmony. These two words were used. This is genuine concern, a concern which I share, my lordships, but the functional disharmony between different authorities, whether it's between the executive or the parliament. The executive naturally either will survive or go, or with the judiciary. In our constitutional scheme of things, there is no room, there is no space, because that will actually erode our own strength. What has been discussed here on justiciability also is important, that what the governor has done by withholding the powers, not giving assent. Whether it's justiciable, the answer is a firm yes. There is no protection which is claimed, which has been explained. It is, if there is a delay in lawmaking, if the governor withholds assent, my lords, question which comes is the office of the governor, which has a defined constitutional role. In certain situations, governor plays an important role, my lords. If there is a complete breakdown of law and order, or the machinery of administration and governance, or there is an external threat to the country, it threatens the unity and integrity of our country, the governor has a defined role. But does the governor have any authority to sit over bills passed by the legislature? That is what I'll say, functional disharmony and conflict. The governor's office cannot be used, my lords, to nullify the will of the people, which is supreme.
That's what has been argued by everyone.
Yes, that's what I'm saying, that it has been. I'm giving, but I'm just doing my duty by...
You are doing, but then, as Sibyl said, that...
No, some things new, which I have said.
Repeat what has already been argued.
That's why I have not quoted even one judgment, because all the judgments are the same.
These points have already been argued by everyone.
Yes, that's why I have
So if you want to address something, you are most welcome.
So that's why I have specifically referred to those articles of the Constitution. Specifically.
We appreciate that on 85 and 86.
Yes, up to 1 to 3, up to the ordinance speaking.
Anything more that you would like to add to what has been already argued by Dr. Singhvi?
Yes, my lord. Well, that is, my lord.
You know that
you have been
your side
very kind.
This side has to complete by tomorrow, at the most 1.5 hours on.
Sure, my lords. I hear it very clearly. If I may say,
we'll go through
seeking your indulgence, I'll just make one comment. This is always the disadvantage of somebody who speaks low down the order. No, because of there is Constitution cannot be, I can't rewrite the Constitution. I'm only referring to what I feel is important. I can elaborate, but I'm conscious of the time. And as I said, I'm grateful that I have this opportunity to make the submissions. But what I would like to say, my lords, that this is where I won't go further. Any impermissible encroachment or by undermining the authority of the state legislatures cannot be and must not be allowed. That is what has to be protected at any cost. The states have their autonomy, that's our Constitution gives, and they must not be belittled or disrespected. The fault lines are there. It is not in the interest of our country. If there is a perpetual state of disharmony, dysfunction, the states cannot be, because of the whims and fancies of the governors, for whatever reasons, if the reasons are constitutional, that are specifically stipulated without any gray area, those are very much there. But if that is not the case, then holding back, that is the case with most of the states. If you have a situation where some states elected legislature, good majorities in their assembly, which is the will of the people, cannot make a law. I know of instances where the chief ministers express their helplessness, even in case of universities for education. And this is true. We have the charts, but I don't want
We
to
are
have
not
given
going to
enough.
that we have made it clear in the beginning itself. Otherwise, Mr. Mehta has threatened us with a list from 1952.
Yes, but I'm not saying something. What is important is that the states, the legislatures, their position in our parliament, the states have their own position in our constitution. That has to be protected, respected. The states cannot be, my lords, either belittled or treated as municipalities that the state.
That's what Dr. Ambedkar replied to that criticism.
Yes.
Dr. Ambedkar was criticized that
Yes.
the constitution, it lowers down the states to the level of municipality. But he went with that allegation and explained. Subramaniam has read that passage from the speech of 25th November 1949.
I was enthralled when he was quoting that speech, and his understanding depth, not only eloquence, but also, I'll say, intellect, is beneficial for all of us, I'm sure, my lords. And I've known Gopal Subramaniam ji for long, and that's why I find him as a person who is grace and also understands the depth, the challenges,
Because
and
you
the
are
serious.
enough to give a pause to his argument so as to accommodate you.
That's what I started with that. I'm ending with this, my lords. I'm grateful to you. Thank you. Thank you, my lords.
Wish you all the best for your
Yes, my lords.
wedding
Thank you.
in your family.
Thank you. Thank you. Thank you.
Well, Lord, let me now come to the second point about 200, because that's the point which is engaging your Lordship's attention. Well, Lord, in Kameshwar Singh's case, there is a passage in Chief Justice Patanjali Shastri's judgment where he says that although the governor is a component part of the legislature, but he really is not a part of the legislature. It is a misnomer to think that the governor is a part of the legislature just because the Constitution says he is one of the components or constituents of a legislature. My Lord, the importance of that, my Lord, is this, that if the governor is in a sense alien to the legislative business of a legislature, then his role is limited and circumscribed by aid and advice. Whether he wants to return the bill, whether he wants to reserve it for the consideration of the president, my Lord, reserving a bill for the consideration of the president, my Lord, is not discretion. It is under the various provisions of the Constitution. It is under those provisions that, my Lord, the aid and advice is given that please do forward this bill for consideration of the president. Even, my Lord, when it goes to the central government, it is also, my Lord, examined through the rules of business of the central government. So, my Lord, rules of business which show aid and advice is always adopted, my Lord, even for the purpose of a message to reconsider a bill under Article 200. So whether, my Lord, whether he grants assent, whether he withholds assent and sends it back to the legislature for reconsideration, or whether he reserves it for consideration of the president, all take place, my Lord, under the aid and advice of the Council of Ministers. My Lord, in fact, all the judgments, if I may say so, except Pavitra's case, that's the only exception. Otherwise, my Lord, all the judgments can be read with reasonable unanimity and a uniform interpretation can ensue, that the intention was that in case you don't follow the procedure contained in the proviso and represent the bill to the governor, it falls through. Well, not falling through literally means it falls. It falls because it's not being represented to the governor. So it is in that interstice, my lord, that the expression falling through has been used, which is why all the passages, my lord, they can be read unanimously. They almost are unanimous that a governor can assent. My lord, the words which are important in the proviso are, as soon as may be, upon the presentation of the bill. My lord, that's very important in the proviso. It shows that when you say that he is withholding assent, it means as soon as, my lord, it's presented to him, he has to act under the proviso in case he is not assenting. So, my lord, predominantly, the intention of Article 200 is to secure the assent of the governor, unless it is a case which requires the assent of the president. My lord, this is necessary because this is the only way in which all the provisions of the Constitution will completely coalesce. My lord, take the case in respect of the proviso to Article 111. It employs virtually the identical language as is contained in the first proviso to 200. If, my lord, under Article 111, the president is bound by the aid and advice of the Council of Ministers and sends back a particular bill for reconsideration on that basis, my lord, there cannot be a different yardstick for the purpose of interpreting the first proviso in Article 200. So, my lord, this synonymity of the nature of the function of the president and the governor is, my lord, central to the theme of aid and advice. And that is why, my lord, I submitted that these are the three steps. First is to determine the cabinet form of government. Second, it runs by aid and advice. And, my lord, the governor and the president are titular heads. The reason, my lord, why assent is required from the president is your lordships have seen that all executive action is taken in the name of the president under 77(1). All executive action is taken in the name of the governor under 166(1). Therefore, my lord, even for the legislative business, the act of assent from the head of state is sought. That is, my lord, the design as far as the Constitution is concerned. My lord, to intervene by any process in this, it must be one which is authorized by the Constitution. My lord, that is why, where, my lord, he has discretion. Suppose, my lord, a governor is appointed as a governor of an adjoining union territory as an administrator. There, my lord, the Constitution clearly says, Article 239(2), that he will act independent of the advice of the Council of Ministers, because, my lord, a union territory does not have a Council of Ministers. Therefore, the Constitution, when it wanted the governor to act in his discretion, it carried, my lord, an express provision. In fact, my lord, even in the 6th schedule, your lordships will notice various paragraphs of the 6th schedule contain provisions which indicate that he will act in consultation with the Council of Ministers. There are some provisions which say that he will act in his individual discretion. Therefore, my lord, it is important to know that when discretion is exercised by the governor by virtue of being a chancellor under a state enactment, or when he decides to give sanction to prosecute, well, that sanction to prosecute is not under the Constitution. That sanction to prosecute is under the Prevention of Corruption Act, because he is the authority who is competent to remove the chief minister or a minister. That is why, my lord, he exercises that power. He exercises the power by virtue of a statute. But here, my lord, we are talking about discretion under 163. My lord, this is the point which I wish to develop for your lordship's consideration. No, I'll continue, my lord. Would your lordships like to pause here? I just wanted to know. Your lordships
Want that to be?
No, my lord. I can start, my lord. I'll start on the same point, but I'll then have a. I'll
start that point afresh.
Yes, yes. I would like to start that afresh. I just wanted to give a summary, my lord, an overview, a synoptic view.
Have you apportioned the time?
Certainly, my lord, we all will.
Wait. We'll give you 1.5 hour more, yeah, on 10th also. And cut down from the rejoinder time.
Grateful.